Hey everyone, it's Rob Ryder. Friday, August 30th, 2013. Continuing on with the Emergency Management Office, and Rose sent this to me, and it's very interesting. Under Emergency Management, they have a coalition of community stakeholders. And if you watch the last video, to me, the emergency manager is the local federal executive, and the one we would be taking complaints to if we can't get any justice in the state courts, because we're under a state of emergency and there's an insurrection, right? The de jure state has been overrun by the de facto foreign power. It's insurrection, and you can't get any justice in the courts. And so the Lieber Code comes into effect, and a bunch of other things, which was all covered in the video just before this, and you would find that by going to YouTube and, doing an upload search, upload date, because I don't remember the names of them. So what's a stakeholder? Well, what is a stake? A stake is a deposit made to answer an event, as on a wager, gambling. Something deposited by two persons with a third on condition that it is to be delivered to one who shall become entitled to it by the happening of a specified contingency. The court could be the stakeholder. Right? They're going to say they have jurisdiction over the property or whatever, but what court are we talking about? It could be an escrow agent, as we'll see, right? But apparently there's community stakeholders. So I think you take your certificate of live birth to the emergency manager of your county and say, who's holding my property? I'm the owner. Where's the stakeholder? A stakeholder is a third party chosen by two or more persons to keep on deposit property or money, the right of possession of which is contested between them, to be delivered to the one who shall establish his right to it. Right? So we need to go to the stakeholder and say, hey, it's my property. Right? That's the big kahuna. That's your certificate of live birth. But let's see how this works with like a foreclosure or something. A stakeholder may commence an action of interpleader against two or more claimants. See also interpleader, which we're going to have to see. But see, they call them claimants, and we'll see here in a little bit. With this function to receive the sums wagered and hold them against the determining event, such as you claiming your title, whether that event be a horse race or otherwise, and then pay them over to the winner. They're just doing it. They're gambling. That's what these attorneys are doing. They're gambling. They're going to be able to steal your property from you. Also, a third person chosen by two or more persons to keep in deposit property, the right to possession which is contested between them, and it to be delivered to the one who shall establish his right to it. Okay, keep on deposit property, right possession which is contested between them, and to be delivered to the one who establishes right. It's distinguished between the one of two or more tenants in common deposit a thing with a bailee. So it's a lot like it, but a little bit different, just distinguished. The duties of the stakeholder are to deliver the thing holden by him to the person entitled to it on demand. It is frequently questionable who is entitled to it. It is not questionable if you walk in with the owner's certificate of title and say, I'm the owner. You're the only one that has one of those. So your certificate of live birth shows that you're the owner of all caps. And if you're the owner of all caps, you're the owner of all the accounts under all caps. And these court cases are just accounts, right, that are now holding the res to your property, which they never signed the contract to, and they never lent you any money, and you've made all these payments, and they've taken your securities, and we're trying to get that shit back. But whenever we go into court, we're told we're not following procedures. So this has got many facets, but let's just go through it. And I probably won't get it done in an hour, because I got quite a lot to go through, and I really don't want to rush. So, when you get ready to watch this, you're going to want to sit in for a bit and maybe watch it a couple times. Yet if before the event happened he has been required by either party to give up the thing deposited by him, such party is bound so to deliver it. So do you have anything to lose if you're in a foreclosure right now? To go find the emergency manager, show him your court case, and say, I'm the owner of the property in dispute. Right? We're the court. I'm the owner of the property in dispute in this foreclosure. And you can also see wagers. A wager, a contract by which two or more parties agree that a certain sum of money or other thing shall be paid or delivered to one of them who they shall gain or lose on the happening of an uncertain event. It's uncertain that you're going to go to the emergency manager and say, I'm the owner of the property, I'd like to have it back. Or upon assertion of the fact in dispute. And that's the fact. Who's the owner? I'm the one that has the frickin' title to Robert Allen Ritlewski. I don't know who else is claiming to be the owner of that property, but I certainly am. But you can also find stakeholders under escrow, stakeholder contracts. But the duty of the stakeholder are to deliver the thing holden by him to the persons entitled to it on demand. And what's this interpleader, though? Because it said that a stakeholder could bring an action of interpleader. Is a civil procedure that allows a plaintiff, that would be the stakeholder, to initiate a lawsuit in order to compel two or more other parties to litigate a dispute. An interpleader action originates when the plaintiff holds property on behalf of another but does not know whom the property should be transferred. It is often used to resolve disputes arising under insurance contracts. Now that's a true interpleader, right? But as we're going to see, they have tweaked the system over time. So the party initiating the litigation, normally the plaintiff, is termed the stakeholder. The money or other property in controversy is called the res. All defendants having a possible interest in the subject matter of the case are called claimants. And this comes in here because here's a foreclosure where this apparent bank is against all these defendants, which include claimants. Since it's claimants, it makes it an interpleader. It's what they use the word claimants with. Claimants goes with interpleader. And as you can see, PNC Bank National Association is suing PNC Bank NA. That's crazy, huh? Now this PNC Bank National Association, you're not going to find a certificate of existence for them, but you probably will PNC Bank NA. Because actually, this is a national association and PNC Bank is just one of the people that's in the association. But it's not PNC Bank NA. Right? It's a fictitious bank or a bank doing business under an assumed name. Interpleader has two stages. First stage is make sure the stakeholder is entitled to an interpleader so it can be discharged of liability, does not know who the property should be transferred. Right? So the whole idea of this interpleader is this guy is saying, I'm not really sure who's this property. I'm going to let the court handle it and give it to them. And let the court handle it. The second stage is like an action at law to determine which of the claimants, right? So which of these claimants down here is entitled to the property. And this plaintiff should have nothing to do with it. But of course, that's the part that they've changed. Now, in the Michigan compiled laws, they don't use interpleader very often, but they did a couple times, and it has to do with a bailee. I'll go do a little more research on this, but right, because bailee is a little bit different than a stakeholder, but really not. Just using different words. So, for instance, in life insurance, the insurance company can file an interpleader. The insurance company is the stakeholder because there's a dispute over who it should go to, let's say. Under the proceeding it was originally developed, the stakeholder would deposit the res with the court, and then the defendants would have the claims adjudicated by the court. Statutory modifications. Typically, once the stakeholder, sometimes allow the stakeholder to retain the res, right? So that's the first thing they did. Originally, you had to deposit with the court. Now they're saying that the stakeholder can hold it. Once the stakeholder deposits the res into the court, the stakeholder is released from the action, and the claimant's proceed against each other to determine, okay. So the first thing they did was they just changed, well, we're going to go ahead and hold it. Instead of giving it to court, we'll hold it, still have the court case, and then we'll just give it to whoever it goes to. But until the stakeholder deposits the res in the court, the stakeholder is still is not released from an action, and the claimants proceed against each other. We could be proceeding against the plaintiff if he hasn't put the money into the court. Except for the denomination of the parties, which is claimants, the action proceeds for the most part, looks just like every other civil action. Is a civil procedure developed under equity jurisprudence. The bill of it's called the bill of interpleader. And bills are used in chancery, actions are used in courts of law. Though originally it was derived the interpleader from form of action at law, interpleader form of action. Now it's a bill of interpleader. They took an action that was used in a court of law and changed it into a bill which is used in a court of chancery. But when they first did it, same thing. Had a few things, such as the stakeholder must not have a claim of any interest. But apparently they do, so they must have changed it some more. And then they did it some more, and they said, you can bring a bill of interpleader into courts of law. So you can bring this chancery interpleader into a court of law by sheriffs and defendants in actions, sump, debt, detinue, or trover. So I think they're really saying that this guy is the, how would this work? Because a defendant can bring the action of a sump, debt, and this is a debt issue, right? So these guys are actually the defendant in another case, and they're bringing it against these people down here. Who does not have a claim of any interest, but they do. So they kept changing it. So formally, a plaintiff had to disavow any claim to the res in order to avail himself of interpleader remedy. But this requirement has been relaxed or abolished, being a bill in the nature of an interpleader. Okay, so it's really not a bill of interpleader. Now it's a bill in the nature of one. Looks like one, smells like one, maybe missing a few seals, a few signatures, just in the nature of one. It's a bill seeking affirmative relief independent of the conflicting claims of the several claimants. Bill in the nature of interpleader may often be allowed to file a party when he asserts a substantial interest in fund or property in controversy. So we may have a bill in the nature of an interpleader because this plaintiff certainly has interest in the property of the claimants. However, for the claimant to be bound by an interpleader, that party must be served process in a way that obtains personal jurisdiction, in personam jurisdiction. They need to use a subpoena. Subpoenas are used for in persona jurisdiction. It's to bring you, the man, in to answer, to show cause why something should or should not be done. And you were not properly noticed because you were not subpoenaed. So that's your first offense. You were not properly notified. And we tweaked this more, and now we got insurance company or fraternal benefit societies could bring these in to the United States District Courts. And they played some more until finally, in 1936, the Federal Interpleader Act again was repealed and replaced with something and established the modern statutory interpleader, allowing suit to be brought by any person, firm, corporation, association, or society having custody of money or property or insurance policy or investment valued at $500 or more, which there are two or more adverse claimant whose citizens of different states, whether or not the claims have common origins, identical, adverse, or independent of each other, and allowed to be an equitable defense in actions at law. So, as long as there's more than one person claiming the property, they're allowing somebody to bring this in as an interpleader. And all they need to do to say there's more than one person claiming the property, it looks like, is call them non-record claimants. They got Brown, so there's one. Anybody else added as a claimant makes this something that could be used in interpleader action. But real quick, let's look what happened. So, where are we at here? Okay, so here's the original case, right? Last name first, Brown. So that really isn't him. Et al. So there's other defendants. It's owner-occupied single-family home, so they're saying Brown is the owner. See, in this case, they're not even going after Brown. That's not his name, right? This is your true, real name for sure. But it's not your true name. Name given to you by operation of law. Okay, so now we have this plaintiff and we have these claimants, numerous ones, and then this is just a complaint. But it created an order of default, right? An order of default against Brown, Aberrinsinke, and man, I thought my name was hard. Okay, against Brown, right? But Brown wasn't listed as a defendant. Well, yeah, he was. There he is. Excuse me, he was. He's not listed as a defendant here on this first page on the cover sheet. So the cover sheet of this doesn't match who it is they're bringing the cause against, right? So Brown didn't get proper notice. But what did they do? They said that Brown is in default. It is further ordered that unknown owners, non-record claimants are dismissed. So we got rid of Brown's in default. We got rid of the unknown owners and the non-record claimants. And then on this one, they got the plaintiff got a default, or got a judgment. Is hereby the summary judgment is granted in favor of the plaintiff against the bank. But they didn't, what did they motion for summary judgment for? They didn't get a final judgment. They did get a summary judgment against the bank. But they said Brown was in default. What does default mean? Under the UCC, default is left undefined, though it is precisely what the parties agree that it is. They're going to convince you it means you did something wrong, yet it's been undefined in the UCC. That's hilarious. Okay. So, it was enacted into positive law in 48. It became 28 U.S.C. 1335, 1397, 2361. Those are the ones that have to do with interpleader. Federal courts have held that because of the deposit of the res with the court, an interpleader action is an action to determine the validity of competing claims to identified property that served may be under, which authorizes other forms of service to obtain in rem jurisdiction, but they're supposed to get personal jurisdiction. Now they're saying they can get in rem jurisdiction. And MREM would be over the res. But it does say federal courts held that because of the deposit of the res, so the court is the one now holding the property. That makes them the third party holding the property. That makes them the stakeholder in a foreclosure. Okay, so 1655, what can they do? In an action in a district court to enforce any lien, lowercase district court, property within the district. The order shall be published at the court as the court may direct, not less than once a week for 6 consecutive weeks. Different types of interpleader, U.S. practice. There are 2 specific types of interpleader actions in the United States lowercase federal courts. Lowercase district court. Lowercase federal court. What court's they talking about? Well, because this is under the emergency management, if you remember where this all started, and we look at a map of emergency management, and we've been told by an emergency manager that she is the civil authority. The district court judge is the emergency manager. Administration, they are an administrative judge. They're actually the chief magistrate. If you think about it, the president's the chief magistrate of the United States of America. As the chief magistrate, he's the highest magistrate over the judicial magistrates, legislative, elective, or executive. He's the chief magistrate over all of them. So the executive is always the highest level. And we're supposed to go to the executive to have the law executed and enforced. And so I think, like here in Indiana, that there's 10 districts. Each of these districts has a chief district judge who's the guy over the whole region, but each county has a district judge who is the emergency manager. And somewhere in that system there is where they're holding the res, because it said it went to the court. So there's two ways to do it with this interpleader. A statutory interpleader action is commenced by the stakeholder, who must initially deposit with the court the amount in controversy or post a specific bond with the court. We're just going to the wrong courts. The stakeholder may, however, at trial claim they don't owe money and claimants at all, and since the action can be in the nature of an interpleader. So they can do all this and put it in, then go into court and claim they don't owe it, right? And that you owe it. And there's a rule interpleader, so there's two kinds of interpleader. Rule interpleader provides remedy for any person who is or may be exposed to double or multiple liabilities. Well, what would that be? That'd be somebody committing fraud. Double, triple damages. Stakeholder may invoke Rule 22 as plaintiff or by counterclaiming in an action already started against him by one or more claimants. There are specific rules, specific differences between statutory interpleader, rule interpleader. These I got to read a little bit more, but that's why I'm putting it out, so that people who understand this stuff better, especially the federal law, take a look at it. And go talk to the emergency manager and say, I want my property back. The stakeholder may claim that they are not liable in whole or part, right? Well, we owe all that but $5, so we don't owe it all. We're not liable for the whole thing. Part or any or all the claimants. It gives them all sorts of outs, right? However, for the stakeholder to be discharged, he must deposit the money or property in the court pursuant to Rule 67. So if he wants to be discharged of paying double or triple damages, he has to have deposited the money with the court. Grounds for an interpleader action by the plaintiff. Persons with claims that may expose a plaintiff to double or multiple liability may be joined as defendants and required to interplead. Yeah, we could expose the plaintiff to double or multiple damages because we're catching for fraud and it's 3 times damages. It can be started by the defendant exposed to similar liability may seek interpleader through a cross-claim or counterclaim. So somehow I think what's going on is, right, because here we have a claim against a bank, PNC Bank putting a claim against PNCNA. They have their own action going on. That's part of what this stuff is they're talking about, but I don't think it really applies to us, as we'll see in a bit. An equitable proceeding brought by a third person to have a court determine the ownership right of rival claimant to the same property is held by that third person. It's held by that third person, okay? It's not, and we've been told that these are, when we go into court, that we're going into a court of equity. You know, a lot of people have been told this is equity. Well, then it's a bill in the nature of an interpleader equity. Typically, interpleader will involve corporate securities or proceeds from insurance policies. the stakeholder and does not know which claimant should be lawfully delivered. So we just need to tell them, well, it's my property, and show them whose it is. But it's the court that has the property now. The court must decide whether the interpleader is proper. The stakeholder is not obligated to deposit the stake with the court, an important advantage when the property is used for purpose of investment and generate income. Claimants must reside in the same state to use this Rule 22. This is used in escrow also, though. If either of the parties does not act as they agreed to or frustrates the transaction, the party terminates the deal, and most likely the contract altogether. The money that was placed in escrow becomes idle because the escrow agent is usually instructed not to release or refund any of the money until the dispute between the parties is settled. So your money's sitting there in escrow. An interpleader action should be entered into when an escrow agent or middleman has no interest in the money that is the subject matter of the dispute and no independent liability asserted against him. An interpleader action requires an intermediary to place the money in the court's custody. And this has to do so they can get their does not walk away and leave parties a dispute for recovering the cost and attorney's fees, right, before recovering cost and attorney's fees. Therefore, an escrow agent is entitled to recover the cost of attorney's fees incurred in filing the interpleader action. Interpleader. The district courts have original jurisdiction of any civil action of interpleader or in the nature of interpleader filed by any person, firm, or corporation, association, society having in his or its custody or possession money or property of value of $500 or more, yada yada yada. It's the district court shall have original jurisdiction in civil action of interpleader, not the court you're walking into, the district court. And I'm just saying, it looks to me like every county's got a district court, and each district has a chief judge, and he's the EMS guy over the entire district or the districts, but each one has a district court, and it's in wherever EMS is, wherever they keep hauling all this paperwork to the 911 building. All right, so that's interpleader. Then the other one they could do, wager of law, right? Because we talked about wager, so there's another way it could be done. This is out of Blackstone's Book 3, Chapter 22, Several Species of Trial, and it goes through all the different kinds of trials there could be. But for us, we're going to concentrate on this one. Might be overborne. Okay, so was to put as sureties, that is, such state who will make his law and that take benefit of which law has allowed him. For our ancestors considered that there were many cases where an innocent man of good credit might be overborne by a multitude of false witnesses, and therefore establish this species of trial by the oath of the defendant himself. We're going to be talking about the decisory oath, right? And when you go into court, you're going to want to take an oath in open court to say you don't owe the plaintiff any money. For if he will absolutely swear himself not chargeable and appears to be a person of reputation, he shall go free, forever acquitted from the debt or other cause of action. Its origin may be traced as far back as Mosaic law. Right? We're going into the law of Moses here. Somewhat similar also to this is the sacramentum decisionis, or the voluntary and decisive oath of the civil law, the decisory oath, where one of the parties to the suit, not being able to prove his charge, the plaintiff, offers to refer the decision of the cause to the oath of his adversary, which the adversary was bound to accept or tender the same proposal back again, Otherwise, the whole was to be taken as confessed by him. And we're not taking oaths in these court cases, and they're open court. You are in court, right? So the plaintiff hasn't taken an oath. He's referring it to you. You can either take an oath and say he's incorrect, or tell him no, plaintiff, you take the oath. Where's your sworn complaint? Otherwise, the whole will be taken against the defendant. But through custom somewhat similar to that which prevailed formerly in the City of London. Oh, okay. Yet in general, the English law does not thus, like the civil, reduce the defendant in this case, in case he is in the wrong. So you don't have to take an oath in case you're incorrect. If you're wrong, you wouldn't take an oath that you're right. That would be perjury. So they don't require you to do it. But it was used in the City of London. Right? And that's who overtook us. So, what does he say? The manner of waging and making law is this. He that has waged or given security to make his law. Now, what's the security you gave? You went and paid to be part of the court case. You know, even when you're being sued and you go to answer, you need to pay for it. That's your security. Brings with him into court 11 of his neighbors, a custom which we find particularly described so early as league between Alfred. Okay, but we're going to find out you don't have to bring them anymore. The defendant then, standing at the end of the bar, is admonished by the judges by the nature and danger of the false oath. And if you persist, he is to repeat this or the like oath. Hear this, ye justices, that I do not own unto Richard Jones the sum of £10, nor a penny thereof, in a manner and form as the said Richard has declared against me. So help me God. Right? You take something like that and you say, I don't owe the plaintiff a penny, so help me God. And if the judge says he isn't going to take it, then you have to say it again. And if he persists, he is to repeat this or the like oath. Right, but then what was supposed to happen is the 11 people were supposed to say, well, we believe him, even though they don't know the facts. They were just supposed to say, yeah, we agree. He's a good man. He won't lie. It was later authorized that fewer than 11 could do, but Sir Coke is positive that there must be this number. Wager of law is equivalent to a verdict in the defendant's favor. It ought to be established by the same or equal testimony, namely, by the oath of 12 men. But it says the same or equal testimony. Well, nobody's has put any testimony in against you. Nobody swore to anything. It must be, however, observed that so long as the custom continued of producing the suit or witnesses to give probability to the plaintiff's demand, of which we spoke in a former chapter, the defendant was not put to wage his law unless the suit was first produced and their testimony was found consistent. If he bring 2 or 3 witnesses to prove the fact, the defense must be made by 4 or 6, so that every witness must bring 2 jurors up to 12. But they're not bringing any witnesses. The plaintiff isn't bringing any witnesses. So that according to the doctrine of 11 compurgators were only to be produced, but not all them sworn. In the old Swedish and Gothic Constitution, wager of war was not only permitted, as it is in criminal cases, unless the fact be extremely clear against the prisoner, but was absolutely required in many civil cases. There's times when it is absolutely required in civil cases. But in England, wager of law is never required, and is then only admitted where an action is brought upon such matters as may be supposed to be privately transacted between the parties. And we've tried to put complaints in against these court cases, and the answers we've gotten from the police and people like that is, we don't get involved in private matters. This suit here is a complaint between the parties about a debt, between private parties. Therefore, it is only in actions of debt upon simple contract, or for an americament in actions of detinue, and of account where the debt may have been paid, the goods restored, or the amount of balance without any evidence of either, it is only in these actions, I say, that the defendant is admitted to wage his law. You can do it in a foreclosure. It's an action of debt upon simple contract. So the wager of law lies not where there is any specificity as bond or deed to charge the defendant. They don't have any paperwork to charge you with. Right? You don't have a deed because both parties didn't sign, so that deed of trust is not a deed. It's a security agreement. You don't have a bond because that promissory note you signed is a security because it has a maturation greater than 9 months. They don't have those things. Nor does it lie in an action of debt for arrears of an account settled by auditors in the former action, and by such wager of law, when admitted, the plaintiff is perpetually barred. For the law, in simplicity of ancient times, presumed that no one would forswear himself for any worldly thing. If you go in there and swear to the fact that you don't owe the defendant any money, they have to take your oath. And you don't need to swear on a stack of Bibles. You need to do what Blackstone said, wherever he said it. Hear ye this, justices, that I do not own unto Richard Jones the sum of £10, nor any penny thereof, in manner or in form as the said Richard has declared against me, so help me God. You just took your oath. I do not own the plaintiff the sum specified in this hearing. Don't owe him a penny, right? We come up with the words, but and then they're going to say, well, you can't do that, and you're going to say, ah, yes, I can, and then do it again. Right? Don't take no for an answer. Get the words out of your mouth, because it was absolutely required in many civil cases, and only in actions of debt upon simple contract. And they never signed the contract, so there is no contract. Wager law, however, lies in real actions where the tenant alleges he was not legally summoned to appear, as well as in mere personal contracts. There's the two places. You were not legally summoned, right? You were not legally notified. You can give that. You didn't get a subpoena. It should have been in persona jurisdiction. But where the plaintiff has given voluntary credit to the defendant, there he may wage his law. When the plaintiff has given voluntary credit to the defendant, there he may wage his law. For by giving him such credit, the plaintiff has himself borne testimony that he is the one whose character may be trusted. But the plaintiff hasn't given us anything. Upon this principle, that an action of debt against a prisoner by a jailer for his victuals, the defendant may not wage his law, for the jailer cannot refuse the prisoner, but otherwise it is for board of diet of a man at liberty, right? So when they charge you in jail for your time there, you were at liberty. Isn't that a wonderful thing to know? Liberty for all. In any action of debt brought by an attorney for his fees, the defendant cannot wage his law because the plaintiff is compelled to be his attorney. But it had been otherwise had the hiring been by special contract and not according to the statute. Okay, so there's special contract between the plaintiff and his attorney, because the plaintiff doesn't show up, it's the attorney that shows up. In no case where contempt, trespass, deceit, or injury, these are places that couldn't be used. The king is also, this has his prerogative, so you can't use it against him. Thus the wager law never permitted, but where the defendant bore a fair and unreproachable character, and also was confined to such cases where debt might be supposed to be discharged, or satisfaction made in private without any witness to attest it, and many other prudential restrictions accompanied this indulgence. Just go in there and swear on oath as the defendant, take the decisory oath, swear on oath that you don't owe the plaintiff anything. And if they sputter, as soon as they get done sputtering, do it again. And make sure you call them justices. So that now no plaintiff need at all apprehend any danger from the hardiness of his debtor's conscience unless he voluntarily choose to rely on his adversary's veracity by bringing an obsolete instead of modern action. So if they're going to bring this old action because it still exists, then you have to go and you have to take the oath. Right? And again, this is trial by wager. And wager was covered under Stakeholder. Therefore, one shall hardly hear at present of an action of debt brought upon a simple contract, that being supplied of an action of trespass on the case for breach of promise, wherein though specific debts cannot be recovered, yet damages may equivalent to the specific debt. Okay, but that isn't what they're doing. It's a simple contract. In the room of actions, the account, a bill in equity is usually filed, wherein though the defendant answers upon his oath, yet such oath is not conclusive to the plaintiff, but he may prove every article by other evidence in contradiction to what the defendant has sworn. So now he has to prove his case, right? And this is what happened with Hugh in the email I sent out a couple weeks ago in his court case, where he put in a really nice complaint and the judge was going to dismiss it. And then Hugh spoke up about the fraud, and the judge said, "Are you saying the bank didn't lend you any money?" And Hugh said, "Yes, I'm saying the bank didn't lend me any money." And after that, the judge said to the plaintiff that he wasn't going to accept their paperwork and that they had 30 days to put in an answer under penalties of perjury. Swear to it. Because Hugh said they didn't lend me any money. Now just swear to it. So that wager law is quite out of use, being avoided by the mode of bringing the action, but still it is not out of force. Could still be done. They could still sneak it in and use it as a form of law, and that's what they're doing. And one last one here. Hopefully I can get this done before I run out of time, so we'll do the best we can. Wager law. A defendant who elects to make his law is permitted to make a statement before the tribunal, swear an oath that it was true, and present one or more individuals who swore that they believed he had told the truth under oath. One or more individuals. You need one witness. It had originated in Anglo-Saxon England in the ties of kingship that brought people together at a period before the year 1000, a time when each man was responsible for the acts of his blood relatives. We're talking Old Testament law here, right? Under the New Testament, I'm not responsible for the acts of my blood relatives. Later, kingship gave way to more tribal affiliation and loyalty to the place of one's birth. Wager at law. When an action of debt is brought against a man on a simple contract and the defendant pleads nil debit and concludes his plea with the formula, and this he is ready to defend against him, the said A.B. and his suit, as the court of our Lord the King here shall consider, and C. He is said to wage his law. He is then required to swear he owes the plaintiff nothing, brings 11 to swear this mode of trial is trial by wager law. But that's the laws of England, and we're not really using the laws of England, we're using the laws of London. The wager law can only be had in actions of debt, simple contract, and actions that continue in consequence of this right of defendant. Now actions of simple contracts are brought in assumped instead of bridging. Detenu, trover, has been substituted. Whatever any of that crap means. Compared to legal wager, which is a provision of surety at the beginning of the legal action to minimize frivolous litigation. Wager law is also called a judicial duel. Surety has a variation. A variation was for the defendant to give a gage or sureties in action of debt that at a certain day assigned he would take a law or oath in open court that he did not owe the debt. That's what happens when you go to answer the complaint and you pay the $260. Now you're supposed to go in and take an oath in open court that you do not owe the debt. Determining fact. Wager of law was replaced by jury. When judges did not determine the fact, but they do now. Wager of law was practiced in England and the U.S., not U.S. This is in the uppercase, de facto, until the 16th century in criminal matters, and in the 19th century in civil matters, and into the 19th and 20th and 21st, supporting defendants' oath. The defendant who elected to make his law was permitted to make a statement before the court, swear an oath that it was true, and present one or more individuals, often 12, you only had to bring one. This was the predominant form of defense in the feudal courts, and it persisted in the time of common law courts. They did not testify about the facts itself. Indeed, they might have no personal knowledge concerning it. That's the people that swore to the defendant being a good person, not that they know anything about the facts. The value of the man's oath might vary with the statute. Sometimes it was necessary for the defendant to meet a charge by assembling oaths of prescribed monetary value. One reason for long survival of practice was that wagers in law were often considered better evidence than account books in cases of debt. And we're talking about cases of debt. Blood relatives swore to good conscience. They believed he was telling the truth. Looks like we only need to bring one. There was the abolition of the wager of law. But let's see what happened. Blackstone says it's Mosaic law. It also has some points of resemblance, perhaps historical, to the decisory oath of Roman law, which is civil law. The term sacramentum is a bond of union between the two stages of law. That sacramentum is when you bring in and pay your $250 to go there and take your oath. Legal usage in Roman law, thing given as a pledge or bond as a sacramentum. The sacramentum, sum of money deposited in a legal procedure. If correct law and procedures had been followed, it could be assumed that the outcome was right or valid. The losing side had thus, in effect, committed perjury and forfeited his sacramentum as a form of something, a sacrifice. The winner got his deposit back. Proceeding originally upon fictitious averment of a promise by a defendant. No wager law is allowed in assumped. Okay. Legal wager in Roman litigation system. In some cases, the party lost the wager, went to the other party to compensate him for the inconvenience. Okay. Both parties lay down their wager. Who are they going to give their wager to? They're going to give the wager to the stakeholder. And they're going to put in a sacramentum, which means you're going to go pay your money to have your say in court. This procedure, fully titled Legis Acto per Judicio Arbitrative, the complaint before the judge or arbitrator, was only used in some in personam cases, laid down by statute and did not require any wager at all. It was therefore much less risky for the plaintiff. And what else we got? In England, the appellant first formulated his charge, which was first complained at 5 consecutive county courts. Lowercase county courts. Courts with the emergency manager over them. Actually, it should be the county executive. He's over all the offices in the county, but if he won't do his job, that's what we're going to the emergency manager. Okay, so anyway, it just seems that these community stakeholders have something to do with what's going on, and stakeholders are the ones holding the paper. It could be the court, it could be it could be who's over the CAFR accounts. I really don't know, right? But somebody's holding the stakes, and if we walk in with our titles and say that's our property, well, they have a duty to give it to you. And if they're starting a court case like this, it's some kind of interpleader, or it's a wager of law, and as the defendant, once you pay your money to go in, you just tell them that you don't owe them any money and swear to it. The decisory oath. Okay, well, we'll leave it at that, and on to something else real soon. See ya.